Tonight, a break in proceedings for the holiday weekend.
Have a great long weekend. We'll see you here Tuesday morning ready to go.
We go over the prosecution's case so far, including key moments from this week. Plus,
I'm anxious for everyone to learn what we know.
As the defense prepares to present its case to the jury, we look at who may be left off the Commonwealth's remaining witness list. And we asked, and you answered. Tonight, our panel of experts weigh in on your questions. Canton Confidential, the Karen Reed murder trial, starts right now.
Court will not be in session until next week, but that does not mean there isn't plenty to talk about tonight. Good evening, everyone. I'm JC Monahan. Glenn is off. The holiday break represents a turning point. The prosecution is winding down, and the defense is gearing up to present its evidence. We have our John Maroney walking us through what's been done so far and looks ahead to the final days of the prosecution.
Do you think they've been less effective than the last time around?
I don't believe so, but I don't know. That's for the jury to say.
Karen Reed's assessment of the state's case against her. She's pleaded not guilty to hitting and killing her boyfriend John O'Keefe with her SUV and leaving him to die in a blizzard.
Hank Brennan's prosecution has been superlative. It's been succinct. It's absolutely state-of-the-art.
Special prosecutor Hank Brennan's style has been different than prosecutor Adam Lally's. He's cut back on witnesses, and so far, 37 have testified compared to 50 at this stage of the last trial. Plus, the defense attorney turned prosecutor is efficient during direct examination. Still, legal analyst Peter Elkin says that doesn't guarantee success.
You can't change the facts, and it's not clear what the results will be because there's plenty of reasonable doubt here.
Unlike the first trial, it appears Brennan won't be calling some of the more controversial witnesses, including former state trooper Michael Proctor, ATF agent Brian Higgins, and Brian Albert.
I think he died right around 12:25, 12:30.
The second jury has heard portions of interviews the defendant gave, unlike her first jury. The impact of Karen Reed, in her own words, remains unknown.
It was very, very unusual that defense counsel would have their client speak to the media.
The special prosecutor does come at a high price. Records show Brennan was owed more than $250,000 before the trial started. Reed has big bills too, and next week her attorneys will get their chance.
I'm ready to put on our case, which will be more robust than it was last year, so I'm anxious for everyone to learn what we know.
The trial is expected to resume Tuesday, and that is when we're expected to hear from the state's last witness, an accident reconstructionist. In Dedham, John Maroney, back to you.
Well, joining us now is defense attorney Morgietta Dorissier, retired Massachusetts judge Jack Lew, and of course our courtroom insider Sue O'Connell. Welcome to all of you. Let's just start with John's story right there. He spoke to attorney Elkin. Do you agree, disagree with what he had to say? Morgietta, we'll start with you.
I think that we're getting into the end of the prosecution case in chief. I think everybody realizes that. But I agree, there's a lot of reasonable doubt that we've really seen. And I think that it's unfortunate because this time around we thought that we'd be getting more information, the presentation and things like that. So, it'd be interesting to see how this last witness kind of plays out.
Jack?
Peter is a wonderful, wonderful lawyer I've known many years, and I totally agree with his general legal understanding, but people would differ. Some people would say there's lots of reasonable doubt here, and some people would say there's no reasonable doubt. I don't really have an opinion on that, but I guess I would have to disagree with that well-respected lawyer, Attorney Elkin, and say half of the population thinks there's no reasonable doubt. I don't have an opinion.
Okay, well then what about the witnesses that are left for the prosecution? Do we feel like they're saving the best for last?
I think they're saving the most concise for last because the first few witnesses were more so storyline witnesses to kind of fill in the details about what happened that evening. And now we're getting down to the scientific. And I think that's really good strategy on the prosecution because you want the jury to be left with that piece of information than some of the mishaps that we heard from some of the witnesses before. So strategically is a good idea.
All right, let's Judge Lew, I want to get this one to you because Judge Beverly Cannone gave instructions to the jury about an issue yesterday morning. She cleared the courtroom, said she would speak with each juror one-on-one. Here's a clip from that moment.
So An issue has come to my attention that is going to make it necessary that I talk to each one of you individually over at sidebar with counsel. So that process will take a little while. So I'm going to don't speculate as to what I'm going to talk to you about. Please, when you go back to the deliberation room, talk about anything but this case, and I'll see each of you individually. And the process may take.
All right, Jack, you have decades of experience. Did you ever have to do that? Bring in a jury one at a time? By the way, a juror one at a time. We still don't know what the issue was.
Yeah, many, many times. And it would be unusual in a trial of this length to not have to do that. It's actually, weirdly, it's very obvious what happened is that, I don't know anything special, but somebody said a juror may have seen or heard something they were not supposed to hear. So what she did is she took each juror and said, did you see or hear blah, blah, blah? If the answer is yes, she says, does that affect your impartiality? And if the answer is no, you're done, on to the next juror individually. And because of the short length of time it took to talk to 18 people, it's obvious they all said no. And the reason, by the way, she looks so happy is because she has 18 jurors in the box.
I was going to say, and they all returned, all 18. Nobody was kicked out. We're referencing Judge Cannone. We just want to answer some viewer questions. This is for Christine, who wants to know, is it a conflict of interest for the same judge to sit for a retrial of the same case, even if it ended in mistrial?
Absolutely not. And I think this issue has come up a few times. And I think what people have to realize is that you need concrete evidence of some sort of bias, some sort of direct conflict that a judge has with a case, not just a small connection. I think that, people have said that she's had connection with the Alberts and the family and things of that nature. But how is that going to affect her ability to be a judge in the case is the key that no one has really been able to really say what the issue would be.
And even if there was no connection, a judge being on the first trial and the second trial is common.
That's actually preferred. That's preferred. You can imagine how it's easier. That's preferred. But if she said, I really don't want to deal with this mega mess, they would say, okay. But it's better for the system that the same judge do it the second time.
And, JC, it's also the same problem that they have with the police in a sense. You want people who are from here. She was a defense attorney. She went to school here. Of course she's going to know people who are here. Would you want someone from Idaho to just drop in and be the judge? So, what do you want here?
Okay, Steve from Methuen is curious, if the second trial ends in mistrial again, will they read all of the jury decisions this time around? That was the big boom from the first trial, saying that they did agree on charge 1 and 3.
So I think the reality is that the judge in the first trial did it exactly the way she was supposed to. The issue is that no one objected, not the prosecution, not the defense. And so the coin could have been tossed either way. So
is that why they didn't ask?
They both had an opportunity. They didn't want to know. And here's the thing.
Don't ask, don't tell.
Exactly. And so obviously it went in a different way. So the defense did everything that they should have as well. But it could have easily gone the other way in the prosecution's favor. And then what do you do at that point? So, you got to pick your battles.
Would you have them polled if it's another mistrial?
Of my own accord, no.
No.
Absolutely. A mistrial, I don't want to burden you with this stuff, but a mistrial is a completely different breed of animal than a verdict. She did it perfectly. If she says, do you have any other verdicts or anything like that on any of the other accounts, she becomes a prosecutor, which, weird thing about this case, number 638, is the defense lawyer, and according to conventional wisdom in this case, should keep their mouth shut at the end of trial number 1, and the prosecutor should ask, ask them to have if they have any other verdicts. But the answer would have been an unhappy answer if the prosecutor had done that.
Absolutely.
All right, so Donna, I should say, reached out to us about what happened after John O'Keefe was found on January 29th, 2022. On the morning of the incident, Karen Reed was required to go to the hospital and undergo various types of testing. Who ordered that, and is that standard procedure? Sue, Morgietta, Jack, we do know that this started with a phone call from Karen's dad, right?
Yeah, she was sectioned, right? Section 12. And when that happens, it's complicated about consent when you're in the hospital, right? And we also don't know if Karen thought in her state if she had done anything wrong or not. So a tox screen, an alcohol screen, those sort of things are routine tests when someone is sectioned, which means you are put in the hospital because someone is worried about your well-being. Can you consent when you're sectioned? Well, sometimes Sometimes that changes hospital to hospital. Getting the information, the data from those tests, I believe the police had to have a warrant to do it. So, you know, when you're in the hospital and you're asked, it happens to all of us, especially if you have surgery, and they go, don't make any decisions, here, sign this sheet, right?
Yeah.
It's sort of the same thing.
And you have to remember that the scene was a frantic scene.
Yeah.
Everybody acknowledged that. And Karen Reed, was probably literally out of her mind that morning. So her dad did the right thing by sectioning her against her will, all right? And she went to the hospital. So I don't think there was anything out of the ordinary that happened.
Well, and to clear that up, if the question is insinuating that there were officials who did this, that somehow they were taking control of Karen that morning and or starting a narrative, that's just not the case, right?
No, I don't think that was the case. I think, again, it was a panic scene. It was a frantic scene. It was a snowy morning. Police were all in the area, family coming out of the house, people coming from different directions. I don't think that it was in any particular way authorities trying to start something.
Yeah, I wish her all the best. I really do. And I wish all the families all the best. But one could interpret what happened as she delayed the alcohol test to her benefit.
Okay.
Right? I have no point of view, but I don't want to see anyone get hurt.
Yep.
All right, thank you for your insight. Don't go anywhere because we do have more viewer questions after the break. Plus, his name has become synonymous with this case, former Massachusetts State Police Trooper Michael Proctor. But as much as he has been mentioned, we have yet to see him take the stand. So up next, our panel weighs in on how his past conduct could impact this trial. And before we go, we want to take a moment to remember John O'Keefe, the victim in this case. The Braintree native was a Boston police officer. After the death of his sister and her husband, John stepped up and became the legal guardian to their 2 young kids. But as we've mentioned many times, and we've heard it many times, John was known for being there for his friends and family.
Until the time of his death, we were just friends, very close friends, and we hung out all the time. The children hung out all the time, and he was the emergency contact list at my children's school to call if something had happened.
John was only 46 years old. You're watching Canton Confidential, the Karen Reed murder trial.
Don't miss any of the Karen Reed murder trial. Get the full recap of what happened in court, expert analysis, and what we could see next. This is coverage you won't see anywhere else. Canton Confidential, weeknights at 7 on NBC 10 Boston.
So submission 7, all the items that are 7- was submitted by Trooper Michael Proctor.
Did former Trooper Proctor inform you of the working law enforcement theory?
Former Trooper Michael Proctor was not present.
It looks like it could say Trooper Proctor.
And state what that is.
It says TPR Proctor.
You knew at the time that Michael Proctor was the lead investigator on the case, correct?
Yes, I did.
Former State Trooper Michael Proctor's name, there it is. It has been mentioned frequently throughout Karen Reed's retrial, but we have not seen him testify this time around. We're back now with Morgietta Dorsey, Jack Liu, and Sue O'Connell. Proctor's handling of this case, we know it's been heavily scrutinized. He was fired in part for his conduct related to the investigation. So that brings us to a question from our viewer, Claire, from across the pond in England, tally-ho. She asks if it's not being mentioned in this trial that Michael Proctor was fired due to his misconduct over the case. What happens if one of the jurors asks in deliberations about him, given that his name repeatedly keeps coming up, and another juror who is aware of the situation from the first trial tells them what happened? Would that be grounds for a mistrial?
So the jurors can only go by the information that they actually hear in the trial, the evidence, the testimony, the physical evidence. They cannot do any outside research. So I would consider that outside research if they're hearing it from a prior juror from the first trial. So I'd be really careful about that.
How about this? A question was asked and it was overruled saying, did you know that Trooper Proctor was let go for drinking, if I recall correctly? I don't know if that was struck or not, but obviously the jury heard it.
And questions, remember, are not evidence. The judge makes that very clear.
Right.
Now, will the jury do their own inference based on that? They can do that. They can use their own common sense. They're humans just like us,
well, can't
so they can infer.
Yeah, but in the deliberation room, can't you go, what was that all about? What was that, Sue, what was all that Proctor stuff about? Mm-hmm. And that's going to make an imprint on your decision, I would think.
My memory is they've been told
Yeah, I think they were told.
In trial number 2, they have been told he was fired.
He was fired.
Because of this case, I think.
Because of, and that was the integrity and the statement. But it also does, the alcohol part, I think, was struck as well. But to your point, can they talk about it and say, this is what I think I heard?
We're not in there. We've heard a lot of talk about timelines this week. On Tuesday, digital forensic expert Shannon Burgess gave us his report about a 3-point turn Karen's car recorded in those late night hours before John was found outside 34 Fairview Road. But what really stood out is the timeline Karen herself gave in regards to when John could have died. Here is a clip from her interview from the ID docuseries shown in court on Tuesday.
John and I argued the morning of the 28th, Friday morning. So we think he died right around 12:25, 12:30.
Okay, timing really does matter, especially in this case. Reed, in a way, added another layer because the timeline she gave right there does not match the other timelines being presented, but she doubled down on her version of events outside court that same day.
I said, we believe. That's what we believe. And I said 12:25, 12:30, and that was based on phone data that we have that everyone has seen now.
Okay, reaction to giving another timeline.
All of those lawyers that she's talking in front of, privately, they're begging her to keep her mouth shut.
Really?
Yes.
And you're a defense attorney, so...
I said it from the beginning, it's a touch-and-go situation. I would not have advised her. However, I understand that the story would have come out anyways, and sometimes it's better to tell it from your own words, but it's definitely the Achilles heel.
Dan, you're outside court, Sue, every day when she speaks, and everyone's hanging on to her words.
Right, because we don't have anyone else to talk to about the case, because there's a gag order on the case, right? And so whenever we talk, I had a wonderful talk with Special Prosecutor Hank Brennan about his suit the other day, which he's impeccably dressed, and I talked with Defense Attorney Robert Alessi about food and the anti-inflammatory diet I'm on. So Karen is the only source of information.
All right, speaking of that ID docuseries and the other media that Reed has spoken with, we have a viewer question we'd like actually all of you to weigh in on. Here we go. This is Molly from Clinton. She's wondering, why didn't Karen Reed's attorney sign a clause with the documentary producers not to air any of her interviews until a true and final verdict was reached?
Because it would be no deal. I mean, we look at the other docuseries that have been made about other murders. The one about the fellow in Connecticut who blamed the staircase,
right.
And then you've got How to Make a Murderer. All of those, they go to you and say, "Can you give us these production?" And if you say, "Well, I don't want to do this unless the trial is resolved," they'll move on.
Well, and remember, Karen Reed and her team went to the producers.
They shopped.
So they shopped it around. So I guess in that sense, Margietta, they wanted Karen Reed's story to get out, in her words?
I don't think any of us could have predicted how the second trial was going to go or is going, and I don't think that any of us knew the strategy of the prosecution. So it's really difficult. But to Sue's point, they wouldn't have gotten the deal. Maybe they're getting royalties. Maybe they're getting something on the back end. Who knows? But they were going to put the story out one way or another. So.
Why is she talking outside of the courthouse? What's the benefit to her? Even if a tiny bit gets to the jury, it's worthless, or it's almost worthless. All she's doing is telegraphing to Mr. Brennan in his three-piece suits, actually, I noticed.
Yes, very nice.
Competing with Ms. Reed, I think, on the best dress category here. But why is she telegraphing to Mr. Brennan what is going on?
Right.
He's going back into his office and they're making transcripts.
Well, it's also fundraising. I mean, this is the other part of it, too, right? Karen is raising money for her case. If she's not getting the moment, I mean, this is called the gaggle, the scrum, when they come downstairs. If she's not getting that moment, then she's not able to really communicate fundraising to a bigger audience.
And this is something I'm really glad we're going to get to, because although we're hearing a lot from Karen Reed outside of court, we have not heard from John O'Keefe's family. So a viewer from Middleborough says, I notice that the media is only speaking with Karen Reed each day. Is there a reason that a spokesperson from the O'Keefe family isn't asked about their thoughts? Sue, touch on this.
Yeah, we do not approach people, right? I sit behind the O'Keefe family every single day. I'm in that courthouse. Sometimes I walk in with them. In the same place I had a conversation with Hank Brennan about his wonderful three-piece suits, I had earlier been standing with Mrs. O'Keefe and Paul O'Keefe. I am not going to speak to them. If they want to speak to me, I will speak with them. But to my knowledge, they do not have a spokesperson who's going out there. I do know there are friends and family who are talking to media outlets, and we'll see that in the future when this trial is finished. But right now, they have chosen not to do that. And it's not because we don't want to talk to them, not because every station, every media outlet would find someone to talk. You don't want to talk to me? Great. Talk to JC, talk to Melody. There's plenty. Talk to Glenn. But they appear to not want to. Also, remember, they have civil suits that are moving forward to the judge's advice. There are civil suits against the bar. There are other suits that are going forward. So they may not want to participate by giving out information that might harm their civil suits or harm this case.
And it's traumatizing, right,
yes.
too. And, right, just call it what it is. It's traumatizing to relive the moment for a second time in court and then talk to people about it outside of court.
Listen, Peggy O'Keefe's face is right there, John's mom, and I find it as a mom, and I'm sure you don't even have to be a mom to understand how difficult that must be. I do want to ask just one, somebody wants just a little inside info. Morning breaks, where do y'all go?
Bathroom, coffee.
Judge, what do? You have 15 minutes. Where do you go?
I go and take care of the million of other emails and texts and things that I have to take care of.
The judge goes to her chambers.
And get something to eat. And
I stay in the courtroom.
Up on the coffee. I'm watching it from home.
A little moment to stretch.
Yes.
Listen, if you have questions about this case, keep sending them our way. The email is on your screen, canton.confidential@NBCUni.com. We'll answer as many questions as we can. And remember to join us every weeknight at 7 on NBC 10 Boston. We'll have a full recap of the latest developments from court, as well as legal analysis. Plus, this week's episodes will be streaming on Peacock starting on Sunday. And if you're traveling for the Memorial Day holiday, a suggestion, check out our true crime podcast all about the case. It's the audio version of our nightly show that will catch you up on all the twists and turns up until this point. You're watching Canton Confidential, the Karen Read murder trial.
Watch LaToya Edwards and Raul Martinez weekdays at 6 a.m. on NBC 10 Boston.